What happens when you die in Georgia? Hi, I'm estate planning and probate attorney Zach Beck with Peach State Wills and Trust, a division of the Beck Law Firm LLC here in Lawrenceville, Georgia, and we'll answer that question in today's video. So, what happens when you die in Georgia? Now, I'll note at the outset here that the point of this video isn't to talk about any afterlife or metaphysical consequences of death. We'll leave that discussion to religious leaders. However, when you die, your estate must be administered. And what the administration of your estate is going to look like will depend upon whether you had an estate plan in place and what type of plan that you had. If you died without an estate plan, then your estate will be administered in accordance with the laws of intestacy. Someone will be appointed to administer your estate, likely an heir or descendant of yours, but it could be a creditor of your estate or even the county administrator. That person will marshal together your assets, pay off all of your valid debts, and then distribute your remaining property in accordance with the state's default plan. That plan begins at looking at any living spouse or children, then works its way down to your children's descendants if you had no living children, then up to your parents and their descendants if you had no spouse, living children, or living descendants of children, and then to further out remote degrees of kinship as needed. If you died with a will, then your executor will file a petition to have your will admitted to probate. They'll file a notice to debtors and creditors in the county newspaper, and then they will settle your valid debts and pay your final expenses. They'll then distribute any remaining property to your beneficiaries in accordance with the wishes that you laid out in the will. Probating a will isn't an overly expensive or burdensome process, but it can take some time. With the required notice periods for creditors, probate generally takes at least 6 months to completely settle an estate. And lastly, if you had a revocable living trust, and all of your assets were properly funded into the trust during your lifetime, or passed the beneficiary designations, then your successor trustee that you named in your trust simply begins administering the assets in accordance with the terms of the trust, without the need for a probate at all. For assets that weren't properly funded into the trust or that didn't pass the beneficiary designations, that remaining property will either be administered in accordance with the terms of a will that you left behind, called a pour-over will, or in accordance with the terms of intestacy, as we discussed earlier in the video. For more information about estate planning in Georgia, download our free guide to estate planning at peachstatewills.com or give us a call at 678-344-5342.